Assalamu alaikum everyone. So today's topic of the video is a much requested topic on drafting contracts. So if you would have noticed from my last video, I had mentioned towards the end that I'll be teaching you how to draft contracts. So I've chosen some very important boilerplate clauses. So what I mean by boilerplate clauses are those clauses which are generally used in more or less every contract. So let's get started. The first one is my favorite, which is governing law and dispute resolution mechanism. Now, funnily enough, this particular clause is included right towards the end of the agreement for some reason, even though that's the most important clause, because in the event the parties get into a dispute, it is very important to know that where they should take their dispute. Should they take it to arbitration or should they take it to litigation? So I've already made a video on why choose arbitration. So for those of you who haven't watched that video, please have a look at that video as well. Regarding the governing law, always make sure that in cases where you choose arbitration as the dispute resolution mechanism, the governing law of the contract is different and the governing law of the arbitration agreement is different. So it's always necessary to make a distinction between the two, so that in the event there is a dispute, let's say, on whether or not the matter should be taken to arbitration, the governing law, in the sense that the applicable law, the statutory law that will be referred to, would be the Pakistani arbitration law. The second clause is confidentiality. So confidentiality is also a very standard clause, and that applies to both the parties. Even though confidentiality would generally mean that all the information is confidential, however, there are certain exceptions to the confidentiality clause. For instance, if there is a law that requires a party to disclose the information, then that would count as an exception to the confidentiality clause. Or an alternate case would be where there is a consent taken by the other party in terms of disclosing the confidential information. Another important aspect to do with confidentiality clause is that even after the contract is terminated, an ideal confidentiality clause is such which protects the confidentiality of information of both the parties even after termination. Then the next clause is indemnification. So indemnification is a very contested clause. No party would agree to indemnify the other party. This is because indemnification is a means to ensure that no third party has a claim on you. So for instance, let's talk about a sale purchase agreement. In this instance, there might be a case where a third party suffers damages in terms of the goods that the seller is selling to the buyer. So the buyer would not want to take blame of whatever damage is caused to the third party as a result of the seller. So that's why an indemnity clause is very important to ensure what exactly would be the damages that you will be responsible for. Then the next clause is representation and warranty. So the importance of representation and warranty is that every party represents to the other party as to what exactly is it agreeing to provide assurances to the other party. So if, let's suppose, a party represents something that is not true, so that would count as misrepresentation. So for example, in the Contract Act 1872, the word representation is not defined, but the word misrepresentation is defined. So there can be two types of misrepresentation. One is the fraudulent misrepresentation and the other one is innocent misrepresentation. So depending on what category of misrepresentation you fall under, the losses will be accordingly. Then the next clause is waiver. So what waiver does is that, let's suppose I suffer damages, right? Or let's suppose there are certain rights that are guaranteed in the contract which I have, and I'm not able to exercise that right for some reason. So that does not mean that I have waived that right and that I can no longer exercise that right. So this clause ensures that every right, every remedy in the contract I am protected by the contract. Failure to exercise it does not mean that I have completely let go of it. Then the next clause is assignment. So assignment is also a very important clause, because let's suppose there is an acquisition taking place and another party is acquiring somebody else's company. Now that company must have entered into numerous contracts and numerous obligations must have been accrued to that particular party. So the assignment clause ensures that any obligations of that particular party who has agreed with a contractual relationship is either assigned to the other party or it's not assigned. So that's why it's important that whenever you are acquiring a company, you go through the contracts and figure out whether there is an assignment clause or not. Then the next clause is force majeure. Now force majeure is a clause which is very standard. It basically means that if, for instance, there is an event beyond the control of a party, let's suppose there's a flood, there is an earthquake, any such event that I am not able to have a control on, and because of which I'm not able to exercise my obligations of the contract. So then in the event of force majeure, I would then notify the other party that this thing has happened due to which I was not able to perform my obligations. So a good contract would ensure that it not only has the force majeure clause, but it also has another sub clause as to how would the notice of force majeure be served to the other party. Would the notice be served immediately that an event has occurred, and would the notice include that how much time period would be required to remedy the damage, or let's say to perform that particular obligation. And then the termination clause. So the termination clause is very exciting. So the termination clause can either be one-sided or it can be mutual. So usually the parties want that it's one-sided, but then that's not fair. So usually it's agreed by both the parties that it will be through mutual consent. And of course, the termination can either be given by providing a reason or by not providing a reason. So termination is very important, because if I want to get out of a contractual relationship, I should be allowed to. I should not be bound to serve a notice if suppose the termination notice does not require a notice to be served. Then the next clause is variation and amendment. So what the variation and amendment clause does is that if, let's suppose, I want to amend a particular clause in the contract, and the other party has agreed verbally that yes, this particular thing can be amended, but later on fails to act upon it. So ideally an amendment clause should be worded such that any amendment would take place through writing signed by both the parties. Then the next clause is notices. Of course, notices is required when you serve a termination notice. At what address will you be sending the termination notice? If you have a wrong address, and let's suppose you serve the termination notice, and the other party is not aware that you've already terminated the contract, and you act upon the terms and the conditions which are laid down in the contract, and then thereafter you cannot even have a claim against the other side, because the contract would have been terminated, especially if it's a unilateral termination clause. A bonus tip. So my bonus tip is not to use templates as much as you can. So people who claim that they do not use templates, at times they end up using templates. So there was this funny incident where in one of the contracts I noticed that the party was referred to as a purchaser, even though it had got nothing to do with seller or purchaser. So if, let's suppose, that particular contract goes to the client and the client sees that the word purchaser has been used, so automatically, no matter what kind of a client it is, it will be very obvious that you basically copy pasted. So guys, my bonus tip is never to copy paste stuff. I hope you liked the video, and if you did like the video, then please subscribe to my channel and like my videos. Thank you.